Have you ever stopped to think about how much laws, just pieces of paper really, can fundamentally change a society, especially after huge historical shifts? Well, today we're taking a deep dive into a really significant piece of legislation from South Africa, a country that's seen, well, incredible transformation. Welcome to the deep dive. Our mission today is to unpack the broad-based Black Economic Empowerment Act, Act 53 of 2003. Most people just call it the B-BBEE Act. We want to explore, why it exists, what its key parts are, the legal background, what it actually means in practice, and its significance today. So whether you're doing business in South Africa, maybe studying law, or just interested, we hope to give you the essential insights.
And we're going straight to the source for this. We're looking at the Act itself, the consolidated version last updated back in October 2014, but checked for legal standing as recently as March 2025. It's always best to look at the actual text, isn't it, to really get the nuances.
Absolutely. Okay, let's get into the core of it. What was this act trying to achieve? To really understand the B-BBEE Act, you have to start with the why. The preamble, the introduction to the act, is incredibly direct. It states very clearly that under apartheid, race wasn't just about separation. It was actively used to control who got access to South Africa's wealth, its resources, even skills.
That's exactly right. And it's not just about the past. The Act points out that even after apartheid officially ended, the economic reality hadn't shifted enough. The vast majority of people were still shut out from owning productive assets, from getting advanced skills.
And this wasn't just a social problem, was it? The act frames it as an economic one.
Yes, explicitly. It says this exclusion meant the economy was performing below its potential. You can't sideline most of your population and expect peak performance, can you?
And there's a really striking warning in that preamble. It basically says, look, if we don't take real steps to bring more people effectively into the economy, the stability and prosperity of the whole country could be undermined. It's framed as a national economic imperative, not just a social justice issue.
Precisely. And that connects directly to the Act's stated goals, which are tied to the Constitution and broader societal aims. It's about promoting equality, yes, but also achieving broad-based participation of Black people in the economy. Driving higher growth, creating more jobs, distributing income more fairly, these are all seen as linked.
So it's quite comprehensive. It talks about establishing a national policy for economic unity, protecting the common market, ensuring equal opportunity. And the objectives get really specific, don't they? Changing the racial makeup of ownership, management, skilled jobs.
Yes, and boosting ownership by communities, workers, cooperatives. There's also a very specific focus on empowering Black women, plus promoting investment that leads to sustainable development, empowering rural communities, thinking about access to land, infrastructure, skills there.
And improving access to finance, especially for Black startups, SMMEs, even entrepreneurs in the informal sector.
It's really a wide net.
So boiling it down, what's the key message here? It seems this act is a fundamental blueprint for restructuring the economic landscape. If you're involved in the South African economy in almost any way, understanding this isn't just about compliance, it's strategic, right? It's about shifting from exclusion to inclusion for national stability and growth.
That's a good summary. It's foundational.
Okay, so with that powerful why established, how does the act actually put these ideas into practice? It starts with language, with definitions.
Yes, the definitions are critical. Take Black people, for example. It's used as a generic term in the Act, covering Africans, coloreds, and Indians. But the legal definition is very precise. It specifies South African citizens by birth or descent, or those naturalized before the democratic transition in April '94, or those who would have qualified for citizenship before then, even if they got it later.
So quite technical, not just a casual term.
No, not at all. And then you have the core concept, broad-based Black economic empowerment itself. The key word there is broad-based. The Act stresses this isn't about enriching a small elite. It's about the viable economic empowerment of all Black people.
And it highlights specific groups within that.
Yes, particularly women, workers, youth, people with disabilities, and people in rural areas, groups often facing multiple layers of disadvantage.
And it lays out strategies to achieve this. It's not just a vague goal.
Oh, definitely. It lists concrete strategies. Yeah. Increasing Black management, ownership, and control, facilitating community and worker ownership, skills development, workforce equity, preferential procurement, and investment in Black enterprises.
It's a multi-pronged approach.
Exactly. Designed to be integrated.
Now, this next one sounds really important. Fronting practice. What's that about?
Ah, yes. Fronting. This is absolutely crucial. The Act defines it as any kind of transaction, arrangement, or behavior that undermines or frustrates the Act's objectives. Essentially, it's about preventing schemes that create the illusion of empowerment without delivering the real substance. It anticipates attempts to cheat the system.
So like pretending to comply.
Pretty much. The Act even gives examples to make it clear.
Such as?
Well, say you appoint black directors or managers, but then you discourage them, subtly or not so subtly, from actually participating in key decisions or activities. That's fronting.
Oh, okay. What else?
Or if an entity gets B-BBEE status, maybe winning contracts because of it, but the economic benefits don't actually flow to black people in the way they're supposed to, according to the structure.
I see. So the benefits are diverted somehow.
Right. Another example is setting up legal relationships with black individuals just to tick a box for B-BBEE points, but without giving them the real economic benefits or influence that should come with that position.
Like a token appointment.
Exactly. It also covers dodgy agreements with other companies to boost your B-BBEE score, where there are weird limitations, or the operations seem unrealistic, or the deal wasn't done fairly, at arm's length, as they say.
So understanding this definition of fronting is critical for anyone operating under this Act.
Absolutely critical, because this is where the enforcement really bites. It shows the Act is serious about genuine transformation, not just appearances.
And linked to that, there's the definition of knowing something.
Yes, that's important too. Knowing knowingly, or knows, isn't just about having actual direct knowledge. It also includes situations where a reasonable person ought to have known something, or ought to have investigated further.
So you can't just plead ignorance if the signs were there.
Correct. It significantly lowers the threshold for accountability. Makes it harder to turn a blind eye.
Okay, so these definitions set the stage. How does the Act then operationalize everything? What's the structure for making it happen?
Well, a key component is the Black Economic Empowerment Advisory Council.
Right. The council, what does it do?
Its main job is to advise the government on B-BBEE matters. It reviews progress, gives input on those important codes of good practice we'll talk about, helps shape the national strategy, and tries to foster partnerships between government and the private sector.
And who sits on this council?
It's designed to be quite high level. The president chairs it, the Minister of Trade and Industry is there, other relevant ministers, plus appointed members representing different groups, business, trade unions, community organizations, academics. Try to get broad input.
Okay, and you mentioned codes of good practice. Are these the detailed rules?
Essentially, yes. Think of them as the minister's toolkit for defining and measuring B-BBEE in practice. They spell out things like how to interpret what counts as a B-BBEE entity, the criteria for getting points in preferential procurement, the specific indicators you use to measure empowerment.
Like a scorecard.
Exactly. And the weighting for different elements on that scorecard. They also guide sectors in developing their own specific transformation charters.
Can they differentiate within the Black people definition?
Yes. Interestingly, the codes can set different targets for black men and women, for instance, specifically to promote gender equality within the broader empowerment goal.
And is there public input on these codes?
Yes, that's mandated. Draft codes have to be published for public comment for at least 60 days before they're finalized. So there's a consultation process built in.
So for you, listening, what's the real impact of these codes? Why do they matter so much?
This is crucial. Section 10 of the Act makes the status of these codes very clear. Every single organ of state government departments, municipalities, and every public entity must apply the relevant codes. It's mandatory.
Must apply them when doing what?
When they issue licenses, permits, grants, when they develop their procurement policies deciding who gets government contracts, when they sell off state-owned enterprises, when they enter into partnerships with the private sector, when they award any kind of incentive or grant. Basically, any significant economic interaction between the state and the private sector is covered.
And for businesses?
If you operate in a regulated sector, think mining, finance, telecoms, you must report annually on your compliance with the relevant code.
So if you want government business or you're in a regulated industry, these codes aren't optional guidelines. They are the rules of the game. Your B-BBEE score, measured by these codes, directly impacts your ability to operate and compete.
Precisely. Your annual report becomes a public statement of your transformation efforts.
But to tie this all together,
there's also a national strategy for B-BBEE, issued by the minister, to ensure a coordinated approach across government and society. And transformation charters, which are sector-specific plans developed by stakeholders within those sectors, like mining or finance, to drive change relevant to their specific context.
Okay, that makes sense. A framework needs structure. But what about enforcement? Is there a watchdog?
There is. That's the broad-based Black Economic Empowerment Commission.
The B-BBEE Commission, where does it sit?
It's established within the Department of Trade and Industry, but it operates as an impartial body with jurisdiction across the whole country.
And its job, is it just advisory like the council?
Oh, no, it's much more than advisory. It's the primary enforcement arm. Its functions are quite broad. It oversees and promotes adherence to the Act, strengthens collaboration, but crucially, it receives and investigates complaints about potential non-compliance.
So individuals or companies can complain to the commission?
Yes, or the commission can initiate investigations on its own if it suspects something isn't right. It also runs advocacy and education programs.
What else falls under its mandate?
It maintains a registry of major B-BBEE transactions. Deals above a certain value threshold have to be registered. And it receives and analyses all those compliance reports we talked about from government, public entities, listed companies.
So it gathers a lot of information.
It does. It's meant to be the central hub for monitoring B-BBEE activity and compliance. It can also issue non-binding advisory opinions to clarify aspects of the Act.
And its investigation powers, how strong are they?
Pretty significant. It can investigate any matter related to the Act, including any B-BBEE initiative or transaction. And importantly, it can make a specific finding on whether something constitutes a fronting practice. That's a key power, given how damaging fronting is.
What can it do with those findings?
It can take matters to court to restrain breaches of the Act or to get other forms of relief.
And if it suspects crime, like deliberate fraud?
This is a critical point. If the commission suspects a criminal offense has been committed, like deliberate fronting for gain, it must refer the matter to the National Prosecuting Authority, the NPA, or the South African Police Service. It can also flag concerns with SARS, the Revenue Service, or other regulatory bodies if relevant.
So it acts as a conduit to prosecutors if things cross the line into criminality.
Exactly. It investigates compliance under the Act, but refers criminal matters to the authorities equipped to prosecute.
What about transparency? Do we get to know about these investigations?
The commission can publish its findings and recommendations. However, there are safeguards. It generally has to wait until any judicial review process is finished, or until it's clear that no criminal prosecution will be instituted, or if there was a prosecution, until after an acquittal. It balances transparency with due process.
And the reporting side helps transparency, too.
Hugely. Remember, all spheres of government, public entities, JSE-listed companies have to report on their B-BBEE compliance annually. Even the sectoral education and training authorities, the SETAs, have to report their skills development spending to the commission.
That sounds like a serious attempt to make compliance visible.
That's the goal. Significant transparency across the board.
Okay, so we have the goals, the definitions, the framework, the codes, the watchdog. Now let's talk about the consequences. What happens if you don't comply, or worse, if you cheat? What are the stakes?
The stakes are high. Firstly, Section 13A is quite direct. If a contract or license or other authorization was awarded by the state based on B-BBEE information that was knowingly false, the state organ can cancel that contract or authorization.
So you could lose the very benefit you gained improperly. A big financial hit.
Potentially huge. But then there are actual criminal offenses defined in Section 13O.
What actions constitute an offense?
Knowingly misrepresenting your entity's B-BBEE status, that's a big one. Providing false information to a B-BBEE verification professional or any organ of state or a public entity, and of course engaging in a fronting practice, that's explicitly an offense.
Anything else?
Yes, and this is interesting. It's also an offense for a B-BBEE verification professional, or even a procurement officer or other official working for the state, if they become aware of someone misrepresenting their status or providing false info or engaging in fronting, and they fail to report it to the relevant authorities.
Wow, so it puts an obligation on the gatekeepers, too.
Exactly. It creates a wider net of accountability. You can't just look the other way.
And the penalties for these offenses?
They are severe. For the main offenses, misrepresentation, providing false info, fronting an individual convicted, faces a fine or imprisonment for up to 10 years, or potentially both.
10 years? That's serious jail time.
It is. And if the convicted party is a company, not an individual,
What then?
the company faces a fine of up to 10% of its total annual turnover. 10%.
That could be absolutely crippling for a business.
It could be devastating. And the Act specifically says the court, when determining the fine, must consider the value of the transaction that was derived from the offense. The bigger the ill-gotten gains, potentially the bigger the fine.
And for the other offenses like obstructing the commission or failing to report?
Those carry penalties of a fine or imprisonment for up to 12 months, or both. Still significant.
What about the courts? Can any court handle these?
Yes, and this is key for enforceability. The Act gives jurisdiction to magistrates' courts to impose any penalty under this Act, including the 10-year sentences or the 10% turnover fines.
So it doesn't have to go to a high court. That makes enforcement much more accessible across the country.
Much more. It ensures these penalties aren't just theoretical.
And is that it? Fines and jail time?
Not quite. There's one more major consequence. The tender defaulter list in Section 13P.
What does that entail?
Anyone convicted of an offense under this Act can be barred from contracting or doing any business with any organ of state or public entity for 10 years from the date of conviction.
10 years locked out of all government work.
Yes, and they get entered into a National Register of Tender Defaulters managed by National Treasury. It's a significant blacklisting.
Does that apply automatically to the whole company if an individual is convicted?
For companies, the court has some discretion. It can choose to apply the 10-year ban only to the specific directors or individuals involved in the offense, rather than the entire company. But the default seems to be the broader ban.
Okay. So taken together, these penalties and the defaulter list really show the Act has teeth. It's not just aspirational.
Not at all. It's designed to enforce genuine transformation and make circumvention extremely risky and costly. It's about practical compliance and deterring bad faith actions.
Right. We've covered a lot of ground there. We've journeyed through the broad-based Black Economic Empowerment Act, looking at its deep historical roots in tackling South Africa's economic legacy.
It's comprehensive strategies aiming for real inclusion.
Those crucial definitions like broad-based and fronting.
And the framework of codes, the council, the commission, and those very significant enforcement mechanisms.
It's clearly a complex but powerful piece of legislation, really aiming for a fundamental economic shift.
It really is. A major intervention.
So that leaves us with a final thought for you to consider. Given the Act's incredibly ambitious goal to reshape an economy historically built on exclusion and foster genuine equality, what's the ongoing role for individuals, for organizations, beyond just ticking the compliance boxes? How can everyone truly embody the spirit of broad-based empowerment to ensure it genuinely succeeds for all South Africans in the long run?